So this video is going to look at the new stunt driving laws in Ontario, and it's part 5, which is your actual court appearance. So as per the new MUMS Act, the Moving Ontarians More Safely Act, you've already finished your 14-day roadside impoundment, you finished your 30-day license suspension, you've hopefully got legal advice and you've either hired somebody or you're doing it yourself because you've been charged under section 172(1) of the Highway Traffic Act, and your court date is quickly approaching. So what now? Well, let's take a closer look at your actual first court date, which is called a first appearance. And this is the first time that you or your legal representative will appear before the court for your stunt driving or racing charge. So when you were charged with stunt driving or racing in Ontario, the police officer gave you what's called a summons. Looks like a ticket and has your court details for your first appearance. It appears somewhere in the middle of the court, and it includes the date, the time, and the court where you need to appear. Due to COVID, many of these courts actually are not appearing in person. It will be virtually, whether by Zoom or by phone, and they'll send you information on how to attend your court date. So what is going to happen at this first appearance in court? Well, here's what's going to happen in court at this first appearance for your stunt driving or racing charge. You are going to meet the prosecutor, with the prosecutor and get your evidence, or at least you should at some point. You are going to meet with that prosecutor, and that prosecutor is going to give you the evidence, which will be put into what's called disclosure. And your meeting or discussion with the prosecutor, although it may not happen in your first appearance, it may be very brief because you're simply checking into the court at this first appearance to let them know that you are there. In some cases, there may be time to speak with the prosecutor, but it's doubtful that's going to happen at a later date. So whether there is time or not to speak with the case is a decision, and is completely up to the prosecutor. After meeting with the prosecutor, you have 3 options to consider for your next step. So option 1, you can enter a guilty plea. The case will end that day, and most of the time the penalties, fines, demerits, driving suspension, etc. will start on the exact same day. Option 2 is you can set a trial date. You can fight the stunt driving or racing charge, and you can set a trial date, which will be at some point in the future. Or option 3, which is you can get a delay, which is usually 3 to 6 weeks. During COVID, it's more, where you get legal advice if you haven't already gotten it. And there is no downside to ask for this delay. It is important to understand that the charge you are facing, the evidence the court has against you, and the penalties that you face, these are very serious. So take the time to make an informed decision. And lastly, a new court date will be set. So assuming you did not enter your guilty plea, you will appear before a justice of peace, and a new court date will be set on the record. And that new court date will either be to give you time to get legal advice or some other option. You'll have to set a trial date if that's what you want. And in either case, it's important to get the proper legal advice, because you need to make an informed decision between delaying or to set a trial date. So what's the difference between disclosure and evidence, which is what you get at your first date? Practically, they're the same thing. Evidence is the facts upon which the prosecution will use to try to prove the stunt driving or racing charges against you. Disclosure is the actual package of evidence that will be given to you at your first appearance or sometime close to that. Disclosure typically includes a synopsis of the police summary of the case against you, the police officer's notes, witness statements, and sometimes a screening form, which is an offer for a resolution from the prosecutor. Now, why is disclosure so important for my stunt driving or racing case? Well, the answer is simple: because the penalties for stunt driving or racing are so serious, which I've mentioned in all my videos and on our website. The legal system is actually designed to give you everything you need to defend yourself properly. And the only way to properly defend yourself is to get all the evidence that the province has against you. Because once you get that evidence, you can see the strengths and or the weaknesses of the case against you, and then you are ready to make an informed decision on how you want to proceed with your case in the courts. And if you decide for any reason that you want to fight the charges, you can then put together a proper strategy to fight the charge, because you now have all the evidence against you. And the only way to guarantee that you get your evidence is to force you to go to court. Example, force you to go to your first appearance, and this is why it happens. Now the question, why is there a delay after getting charged with stunt driving or racing and my first court date? Well, this all has to do with first appearance. They're usually scheduled 4 to 6 weeks. COVID's make it sometimes longer after the police charge you. And this delay allows the police to properly gather all of the evidence that has to be included in your disclosure. So can I get all the evidence against me? Well, yes, you legally have the right to it, to get all the evidence that the court has against you. And getting all your evidence is not a choice of the prosecutor or the court. The court must give you all the evidence. If you do not get all the evidence, it may be possible to get the charges against you withdrawn in court. Now, will all the evidence be ready at my first appearance? It should, maybe, occasionally, but occasionally the evidence against you may not be ready by the time you arrive at your first appearance. And if this is the case, the court will simply set another date. And the court and the prosecutor, it will give them more time to get that evidence. However, if after a few court dates you still don't have your disclosure evidence, the Justice of the Peace may dismiss the charges against you. So when I get my disclosure, is that all the evidence? Not necessarily. And this is very important to know, because when you get your disclosure, that does not mean that you have all of the evidence against you. In fact, your disclosure package may be missing some key elements of evidence, and if you suspect that there is anything missing in the evidence package, you can ask the court and the prosecutor for that additional evidence, because getting all the evidence is critical for you to be able to make an informed decision on how you want to proceed with your case. So will the police officer that charged me be at this court appearance, my first appearance date in court? Well, no, the police officer is not required to be at your first appearance. If your case does go to trial, then yes, the police officer that charged you will be called upon to give our backup the evidence that he or she has against you. So, you know, I've answered this in other videos. Is this first appearance a trial date? No, it's not a trial date. It's just a first appearance. It's the first time you appear before the court, and you're sort of checking in with the court to put your name on record and, you know, get further instructions, usually to set another date to gather that evidence, investigate that evidence, get legal advice, get some help, get a strategy. So do I have to attend my first appearance? Well, if you've hired a lawyer or a law firm, then no, they'll attend on your behalf. But because your lawyer will actually attend and act as your agent. If you have not hired a lawyer or a law firm, then yes, you have to attend your first appearance. So another question people ask is, can I have someone who is not a licensed lawyer attend on my behalf, a friend or somebody who's gone to court before? Well, generally no. For the first appearance, you may be able to have someone attend on your behalf, but you should give that person written permission that they are allowed to attend on your behalf, and include the reason why you are not able to attend court.